Senators Schroer,
Here.
Gregory 15, Brown 26, Berger, May, Roberts, Schnelting. You have a quorum.
Having a quorum, I now move that we go into executive session. Do I have a second? Having a second from Senator Schnelting, we are now in executive session. I now move that Senate Bill 904 be brought before the committee. Do I have a second? The bill is now before the committee. Do we have any discussion on Senator Gregory's bill on intoxicating THC?
Just very briefly.
Yes, Senator Roberts.
I'm going to vote for this in committee, but I do have some concerns that I kind of addressed during the last hearing we had with the enforcement mechanisms and some of the triggering language.
Any further discussion? Seeing none, I now motion do pass Senate Bill 904. Do I have a second? Having a second, Mr. Secretary, please call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May, Roberts, Schnelting. 4-0.
By your vote of 4-0, Senate Bill 904 is now voted do pass. I now move that we bring Senate Bill 888, my bill on juvenile law reform, Senate Bill 888, before the committee. Do I have a second? The bill is now before the committee. Any discussion on Senate Bill 888? Seeing none, I now move that we vote do pass Senate Bill 888. Do I have a second? Mr. Secretary, please call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May, Roberts, Schnelting. 3-1.
By a vote of 3-1, Senate Bill 888 is now voted do pass. I now move that we bring Senate Bill 977 before the committee. Do I have a second? The bill is now before the committee. I have a Senate committee sub, which has been distributed via email and in person. If you don't have one, please let me know and we can get that to you. Ending in .02C. Senate committee substitute merges Senate Bills 977 and Senator Nicola's 1011 together. Any discussion on this bill? Seeing none. I motion to adopt the Senate committee substitute for Senate Bill 977 and 1011. Do I have a second? All in favor signify by saying aye. Aye. All opposed say no. And the ayes have it. The Senate committee substitute is now adopted. Seeing no further discussion on these two bills, I motion do pass Senate committee substitute for Senate Bill 977 and 1011. Do I have a second? Mr. Secretary, please call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May, Roberts, Schnelting. 4-1.
By a vote of 4-1, your Senate Bills 977 and 1011 are voted do passed. We are now out of executive session, and the first bill up is Senate Bill 969 from Senator Fitzwater. Just a reminder, Senator Fitzwater, you'll have 3 minutes to present, and then turn it over to your first witness that will have 5 minutes, because we like your witnesses better than you.
Thank you, Mr. Chairman. Happy to stand for 3 minutes. It shouldn't take 3 minutes. I'm Travis Fitzwater, Senator from the 10th District, bringing before you Senate Bill 969. This comes from two very specific instances in my district, so I'm going to bat for constituents on this bill that were specifically asked, two separate situations. But the first provision in here ensures that Tier 3 sexual offenders can't be on school grounds. Kind of takes this off the plate of superintendents. We have a family I've dealt with that has this situation. It's created real consternation in a school district. Superintendent that I've discussed this with also wants this removed from their, kind of their purview anyway, and they want to protect their schools and activities and things and make sure they're safe environments. And the second provision, the second piece allows individuals that are victims of dangerous felonies to appear in court virtually if they're under the age of 19. And that is a sexual assault victim in my district that was traumatized by her need to be in a courtroom And so we're providing another avenue for victims to be in front of a court, to hopefully to provide justice to their to the folks that have victimized them. So those are the two pieces. They come directly from constituents in my district, and wanted to try to go to bat for them, and that's the genesis of this. Happy to take any questions.
Thank you, Senator. This is pretty similar to a bill that you had last year as well, correct?
That's right. This comes from a bill that was heard last year.
Senator Roberts.
Very briefly to inquire. Yeah, I remember this from last year. Does this just increase the age, or what was it we did last year?
I believe it may have been 18 and under, and so we said, if you're 19, we wanted to make sure 18-year-olds also had the ability. So I believe the age went from 18 and under to 19 and under.
Okay, thank you.
Any further discussion? Senator Gregory.
Yeah, real quick, Senator. So what's the current status of the law
For which piece?
for the Tier 3 registry? Are they allowed?
So right now, they can get approval from the school district and a superintendent, basically individually allowed if they go the way I understand it. And this one particular situation, a Tier 3 sex offender has been approved by the school district to be at their kids' games. And it's just created a pretty harsh environment.
Gotcha. Thank you.
Any further discussion? Senator Roberts.
Yeah, one more along that same line of questioning. So if this person's a parent at the student for the school, they wouldn't be able to, I guess, apply to the school and say, hey, I want to come see my son or pick them up from school.
As a Tier 3 sex offender, yes.
Okay. All right. Thank you.
Any further discussion? Seeing none, your first witness in support, please come up. Make sure you have a witness form, which should be up there. If you haven't filled them out, you can fill them out before you leave. First witness in support of Senate Bill 969.
Hey, good morning. I know we have a lot to get through today, so I do not need the 5 minutes. I'm Jessica Seitz, the Executive Director of Missouri Network Against Child Abuse, and I just want to go on the record in support of this legislation, specifically the pieces around allowing witnesses to testify virtually or victims to testify virtually. I represent child advocacy centers, and their sole mission is to reduce the trauma of testifying in front of perpetrators of sexual abuse. So this legislation, we believe, is in line with that mission.
Any questions? Senator May? All right, seeing nothing. We're going to move to opposition. The first witness opposed to Senate Bill 969, please come forward. Circle over to informational purposes. Back to witnesses in support of 969. Last call for Senate Bill 969. Support? Opposed? Seeing nothing further, any closing remarks? That'll conclude the public hearing on Senate Bill 969. Senate Bill 893 from Senator Carter. I think she was in here. Yes. And again, reminder, you'll have 3 minutes for presentation. We'll open it up to questions, and then 5 minutes alternating.
Thank you, Mr. Chairman. I will just briefly go over the content of the bill and then defer my time to my colleagues and those here to testify, since there are so many here to testify on behalf of this piece of legislation. Senate Bill 893 represents a critical step forward in modernizing Missouri's laws to better combat sexual offenses and protect our most vulnerable citizens, especially children. This comprehensive legislation updates outdated terminology, replacing terms like child pornography with child sexual abuse material to reflect the true nature of these crimes as acts of exploitation and abuse. It introduces new offenses such as grooming of minors under Sophie's and Evie's law, which targets predatory behaviors aimed to preparing children for sexual acts with mandatory minimum sentences to deter offenders. Additionally, the bill enacts Evans Voice Act to strengthen penalties for non-consensual dissemination and threats of sharing private sexual images, ensuring victims of all ages, including minors, receive justice and restitution while expanding offender registry requirements. With that, Mr. Chairman, I will defer to those here to testify.
Senator, I know you're going to have a substitute that we're going to drop whenever we vote this out. Can you explain some of the changes between the original bill and the substitute?
Yes, thank you. So the content of the bill, this is a merging of legislation that we had ready on the Senate floor at the close of last session. We have the signatures from a conference, a committee, but it just wasn't able to get across the finish line due to the last minutes of session. So what this is, we combine that legislation with the updated sexual grooming and exploitation language. That's really the difference, is just adding those two layers to what had already passed the Senate and the House and just was waiting for a final vote to come to the floor.
Any questions for Senator Carter? Senator Gregory.
Thank you, Senator. I'm just quickly skimming for the exceptions. Obviously, we don't want the situation where, 18-year-old seniors dating 17-year-old junior in high school, and we've got an issue. I think there was an exception, and I'm trying to find it. What are exceptions of those? Do you know where that is? Where I would find those?
I'm happy to talk with you more about that. Some of the breakdowns, we're trying to make sure that whatever language is already currently in statute dealing with minors is consistent with this language. There was some talk about 18, 17, and under, and 18 and over, and minors being impacted. And so what we tried to do, we just went through that. I don't know that it reflects changes in this legislation currently as it is, but it will be, if we update it, it will be, it's either in it or will be where it's consistent with statute now. So adding more clarity.
Oh, I see it. Shall not apply to anyone over the age of 18, but not more than 4 years older. I see you trying to address it. I'll read it right
Yeah,
now. Thank
thank
you so
you.
much.
Any further discussion? Seeing none. First witness in support of Senate Bill 893, please come forward. You'll have 5 minutes. Make sure you fill out your witness form.
Good morning. Thank you for your time. I am witnessing in favor. My name is Jeff Dixon. I am a father of daughters that are victims of sexual grooming. I will keep this short and brief. Currently under the law, there are no repercussions that can be given. My daughters, thank you. My daughter's groomer is actively still teaching martial arts. These are 17,000 text messages between a 52-year-old man and teenage girls. Inside this situation, inside these text messages, we have a bruising game where we exchange pictures of bruises. We have requests for joint banking information where we can create banking accounts together, play with crypto. We have requests for trips to Florida, ultimately running away from his family to be with my daughter and live in Florida, to make children, requests to draw children, what their children might look like in artwork and art forms. It's pretty egregious. So currently there is a big gap in the law. I can go on and on and on about the horrific things that my family has experienced with this giant gap in our current legislation. And again, I just want to reinforce that we are not talking about good, natural conversations. We're talking about a pattern that leads and is attempting to lead to egregious sexual activities. Welcome any questions.
Any questions? Senator Gregory.
What is, obviously those are horrendous situations. What is the closest current law so I can see what the big gap is? I mean, you've reported it to prosecutors.
Yeah, the
And-
closest one in my case would be enticement. We currently dealing with a pretty heavy legal situation. Enticement is not likely because of age of consent. So what the pattern of a groomer is to convince a child to move forward with them. And enticement is very tough, very difficult.
So you've reported it to authorities,
Oh, yes,
course.
absolutely.
and they have not been able to press charges on this guy?
We're hearing from our local prosecutor that they don't think they have a case they can win.
What county is that?
Polk County, Missouri.
Thank you.
Thank you.
And sir, I just want to thank you for fighting for your daughter. It's a terrible situation with all the text messages, and we'll do our best to try and work with law enforcement to make sure that that doesn't happen again.
Yeah, thank you for the committee's time. It means a lot.
Any further questions or discussion? Senator Berger.
Thank you. How were you able to find out about this that was going on?
My daughters were at a rock concert where he requested that they turn off their phone tracker. They were at a concert with him. I'll be quick. He asked my daughter to dye her hair, wear different clothes. If she did not have those things, he would provide those for her. Turn off the tracker on your phone. Madison found them in my parking lot early in the morning, or in my driveway. We live out in the country, and reported it to us the next morning. We found the phone, and our whole world unraveled. My daughter, the whole time, felt like she could handle the situation. She pushed for boundaries, and it just spiraled out of control. It ultimately led to my daughter planning her suicide 7 days after my birth date.
Thank you for coming forward. I know it's been tough. Appreciate you being
Thank
here.
you for your time.
Any further questions? Seeing none. Thank you again for your
Thank you,
time.
gentlemen and ma'am.
Senate Bill 893, those opposed. First witness in opposition, please come forward. I'm going to move to informational purposes for 893. Back to those in favor of 893. Are there any here opposed to 893? By show of hands. Make sure you all fill out a witness form, leave it on the table before you leave, and proceed when ready.
Thank you, Senator Carter, for your support in the legislative action, and thank you guys as committee members for hearing us today. My name is Brad, my wife Carrie Bettler. We speak today on behalf of my son, our son, Evan James Bettler. Our son was a happy and active 16-year-old student. He played soccer, was a member of the Youth Empowerment Club, and worked side by side on various community projects with us, supporting Habitat for Humanity, beautification projects, and school alumni projects. He was a very charismatic young man, rule follower, well-behaved, and was often the student who would befriend those kids who maybe didn't have a friend and maybe sat by themselves at lunch. On January 3rd, we received a text message from our son, and seconds later we heard a noise that was unmistakable and will probably stick with us forever. He took his own life. Through the shock of hysteria and consolation from family, friends, community, and questions, the big question became why. This is a young man that had no symptoms or signs, no depression, no relationship issues, no problems in school. He was a great young man and no precipitating factor. The police department immediately took his phone, looked through it. They found no information or reason as to why he took his life. They investigated kids, community members, teachers at school, family, nothing that really was a precipitating factor. A month later, on February 6th, my wife was pretty adamant about searching his phone every single night. On February 6th, a message thread popped up that hadn't been there before. It showed one picture, and it said, "I have your pictures. Now, are you ready to comply where I post and you get your life ruined in seconds?" The first thread of messages was for hours. It demanded money, demanded bank accounts, demanded gift cards. If he didn't turn this stuff over, that his life was basically going to be ruined. This was a young man, he was nominated for the male student in our school to go to Missouri Boys State. He was well known in the school and community. He was a youth soccer coach, an avid hunter, fisherman, and he had a promising future. The relationships, the person he was, and the moment, it was going to all be destroyed. So we're an open, involved family. We have discussions. We educate our kids. We're both educators, so we're aware of like social media harms and social media dangers for our kids, and we were open about those things that we're aware of. After we lost Evan, we've learned a whole lot about sextortion. We've become way more familiar with it than what we'd ever want to be. And unfortunately, it's a topic that a lot of people are not familiar with. in that month time, in February 6th, we found out, we really didn't share that information with anybody. It was us and local law enforcement. We spent a month kind of trying to figure out what we were going to do with it, because Evan paid the ultimate price to keep this information quiet. We decided to go ahead and go public with it because we wanted our family, our community, and others to know the precipitating factor that led to Evan taking his life. And as soon as we went public with it, we immediately started getting messages about, hey, it happened to my kid. Hey, it happened to my kid. And as parents, that was frustrating, because had we known it happened to other kids, we would have had that specific conversation with our child. But we didn't, and that led us to start Evan's Voice, which now we go around to schools. We've been to several schools in Southwest Missouri and talk about sextortion, and almost every single time we talk, we get messages directly after from kids or families that it's happening to them, it happened to them, and it's happening within their friend group. With our communication between other families, we've also learned that this is a crime that is happening inside of schools between kids that are walking the hallways together. One kid will start extorting another student inside the exact same school. So in 2023, the NCMEC, National Center for Missing and Exploited Children, had 186,000 reports. Just between 21 and 23, there was a 300% rise. And in October of 2024, there were reported, and these are just reported because a lot of kids don't report it because of the guilt and the feeling ashamed of it. There were 456,000 reports. Thorne reports that 1 in 5 teens have experienced extortion. So we determined that if Evan could save lives and keep others from falling into the same trap, that's what we would choose to do. Technology can be extremely helpful in ways, but it's also clear that technology allows a direct avenue into kids' homes, into their heads, and it causes quite a bit of damage. The need for state legislation and law to hold criminals accountable is necessary to help and protect our kids, our grandkids, your kids, and kids across the state of Missouri. Senate Bill 893 is important. It modernizes Missouri law to address digital exploitation by strengthening penalties for sextortion and the non-consensual dissemination or threatened dissemination of private sexual images, particularly when the victim is a minor or a vulnerable person. The act centers victims by requiring restitution for counseling, medical care, education disruption, relocation, and removal of the image from the internet, and also by allowing civil remedies that recognize emotional harm as real and able to be compensated. It enhances public safety by addressing the digital age and the listed offenses requiring sex offender registry. We support this bill wholeheartedly. We appreciate that Ms. Carter has also brought it to the attention of others, and we just want to protect kids, other families from experiencing the same thing that we have.
Thank you for your testimony. Thank you all for being here, and very sorry for what you've gone through. We look forward to working with you to try to fix that. Any questions for the witnesses? Seeing none. Again, thank you for your time. Make sure you leave your witness form. Anyone in opposition, please raise your hand. Anyone for informational purposes? We'll continue in support on Senate Bill 893. Please come forward. You'll have 3 minutes.
Good morning. My name is Susan Hickam. I am the Chief Executive Officer for Lafayette House in Joplin, Missouri. We help all victims of domestic and sexual violence, as well as those who are suffering with substance use disorders. I have 4 years' experience as a previous organization that's similar to Lafayette House out of Arkansas. Plus, I was nearly 21 years serving as a United States Probation and Pretrial Services Officer for the Western District of Arkansas. I'm here today to really speak to the compensation portion for victims as part of this bill and the importance of having that piece in this bill so that services that Lafayette House can continue to provide to all victims of these types of crimes. But I think the other part of this that you need to understand is that we are also here to serve the families. So while we do have the crime victims compensation, you also have the victim services in which fines and penalties will go towards that. That allows organizations such as Lafayette House, as children advocacy centers, et cetera, to continue providing the services to all people who are affected by such crimes. But also we can look to providing prevention. Such funding will allow us to go into schools, create educational activities for schools, for children, for families, for educators, and this piece is important to ensure that this continued funding is available so that we may serve all victims. The Rape and Abuse Incest National Network shows that there are 1,000 sexual assault cases for adults and children per, and from that 1,000, 50 are reported and 28 are prosecuted. That means that organizations such as ours are helping that additional 900 that are affected by such crimes. So this piece of the crime victims compensation and victim services, which will allow for this continued funding, is very important to all victims.
Thank you for your testimony. Again, open it up for questions. Seeing none. Next witness in support of 893, please come forward. You'll have 3 minutes for your testimony. Make sure you fill out your witness form.
Good morning. I'm Angie Brower. I'm the Chief Clinical Officer for RAFA International. We have homes overseas for residential for minor females who've been trafficked, human trafficking. But in Joplin, Missouri, we have an outpatient trauma therapy center that deals with a lot of kiddos and adults who have been exploited in many ways, many kinds of traumas. But what we're talking about today is sexual exploitation. And I just wanted to share the ramifications of what we see from children even before molestation or perpetration has taken place. Grooming alone, the reason this bill is so important, that it should carry a heavier penalty than it does now, that it should be punishable as a criminal offense, is that we see the after effects it has on children and their entire families. When grooming alone is what has happened, it is damaging enough. We see psychological impacts they might carry for the rest of their lives, depression and anxiety. We see kids with PTSD, nightmares and flashbacks. We see kids who've lost all sense of trusting their own intuition, of trusting their own judgment when it comes to who is a trusted adult, right? We tell kids, go talk to a trusted adult. They don't know what that means anymore. Who is a trusted adult? We see it affect their attachment abilities, their relationships with not only other kids, teachers, but also their own families. Even though they know their families may not have known what was happening, they still wonder why they weren't protected. And when a child can't pursue justice, when a child's family cannot for them pursue justice for something like grooming because there is no basis to pursue justice for that offense, they feel like, so it was my fault. This person has been telling me it was my choice, even though we know they can't give consent to something like that because they are a minor. This person has been telling me it's my choice. This person has been telling me we're special friends. This person has been telling me it's something I want. And if the other adults in my life can't prosecute this person and try to get justice for me, then that must be true. It must be something that was okay. It must be something that I was a part of. And then they carry that shame for the rest of their lives. The National Health Institute, along with Polaris and Thorn, between those three organizations, you can look up the statistics for children who've been exploited at the grooming level, even before a sexual act takes place. Their risk for suicide is anywhere between 2 to 10 times higher than children who have not experienced that. That is an epidemic. And sadly, it's an epidemic we often don't know is happening because they're not telling anybody until after the fact, like the parents who talked today that found out after the fact what was happening to their son. So we are looking at children who either attempt or complete suicide. For those children who don't complete suicide, we are looking at generational trauma. We are looking at substance use disorders, generational trauma that goes down to their children and the children after that. If we could step in beforehand and give these kids some justice, take the burden off their shoulders so they realize this really wasn't my fault, this really was an act perpetrated by an adult who knew better, we would be giving them such a better start in life. This can affect their development, the level
While
of
your time
shame
is
they
expired,
carry.
I'll give you
Yeah.
a couple seconds to just
Sure.
complete.
The level of shame they carry affects their entire development.
Thank you for your testimony. Any questions for the witness? Seeing none. Going to move to the next witness in support. Please come forward. You'll have 3 minutes.
Chairman, members of the committee, thank you. I'll be brief. My name is Wes Coatney. I am the Chief of Police for the Aurora Police Department in Aurora, Missouri, down in Lawrence County. Prior to taking that position, I was the investigations manager for the Missouri Department of Corrections, so I appreciate you welcoming me back to Jefferson City. I've been in every prison in Missouri doing criminal investigations on the residents there and staff, and I have kind of a unique perspective as to what a criminal can do and how manipulative they can be. They are able to manipulate grown staff members into bringing things into a prison, let alone a 13, 14, 15-year-old child. So I received the call about Evan Bettler and took over the investigation and did an investigation into who Evan was. Evan was not a troublemaker. Evan was not looking for trouble. Evan was stable. Evan was a good student. Evan was liked. Evan was not having relationship problems. And we absolutely could not find a reason why he stepped out into his backyard and took his own life. Call it divine intervention if you want. His mom, laying in bed one night, finds a message that I'm telling you was not there prior. We pulled the data off of the phone, and a message popped up on his Instagram that showed that he was being exploited for a photograph that he had sent to who he believed was a girl. Turns out it was not a girl. Turns out it was somebody that then used it against him to try to gain $500 from him. He didn't have $500, and he believed that that person was then going to release those photos. And his mom and dad are both educators in a small town, and he believed that he was going to disappoint them to the point that he couldn't face it. And so he stepped out in his backyard and took his own life. Tragedy is an understatement in this situation, but it happens so much more frequently than I really knew even as a law enforcement officer. The gentleman that testified before indicated that there is a gap. So if today somebody comes to my police department and says, hey, I think somebody's trying to gain access or gain communication with my child, as you know, law enforcement is very often reactionary. So at this point right now, unless something was really, really egregious, I don't have much enforcement power. If something kind of has to happen more, it was mentioned about enticement of a child. If we get to that point, then we can kind of take action. But with this grooming, Evan's case is unique because you've got an exploitation section of this bill, and you've also got a grooming portion of this bill. Evan was both. He was groomed, and then he was exploited. And if Evan had reached out for help with this bill in law, we would not only have an ability to hold someone accountable, but we would also have mechanisms to apply for search warrants and get that data from those social media sites that are sometimes difficult to get that data from.
While your time has expired, we'll give you a couple seconds.
So I just wanted to say that I'm in support of this bill, and it would give us a tool to hold people accountable before a child's life is lost. Thank you.
Any questions? Just want to commend you and thank you for all your work in law enforcement and serving the state.
Thank you.
Next witness in support. Please come forward. I know I don't have to tell you about the witness form. We've already got one.
Thank you. Good morning, committee members. My name is Locke Thompson. I'm the Cole County Prosecuting Attorney here for the Prosecutors Association. We are here to voice our overall support for the bill, the concept of the bill. We do have a couple of concerns or maybe recommendations for a couple of changes we might like to see, specifically maybe doing a little more to differentiate the grooming portion of the bill from our existing enticement statute. whether by changing up the language a little bit or maybe even incorporating that grooming language into our existing enticement statute. And then with regard to the exceptions or exemptions from the bill, we have concerns about any time that there is no evidence of force, threat, any time that there is no evidence of sexual intent or exploitation by a person, obviously they wouldn't be in violation of the statute. So we do have some concerns about specifically giving exemptions to licensed teachers, healthcare providers, youth mentors, parents, guardians, or family members when, in my experience, having been a prosecutor for 10 years, those are some of the people most likely to abuse children and to be able to hide it better. So I think we might like to see that changed as well. But other than that, we are in support of the bill and the concept behind it.
And I think that Senator Carter will be willing to work with you and make some changes. Any questions?
We did take out those portions in the new sub.
Oh, in the sub, that's, okay.
And we'll get you that substitute.
All right. Thank
Any
you.
questions? Seeing none. Thank you again for your time. Next witness in support, please come forward. You'll have 3 minutes on Senate Bill 893.
Good morning. Jessica Seitz, Missouri Network Against Child Abuse. Again, most of the points I was going to make were just made by Mr. Thompson. We are very much in support of taking a closer look at grooming behavior. Child advocacy centers serve over 10,000 kids every year through providing forensic interviews during investigation. The majority of those cases are child sexual abuse. So when this legislation was introduced, I had them take a look at it, run it by some of their multidisciplinary team partners, and I did speak with several prosecutors. So we know that grooming behavior is basically assured in cases of child sexual abuse by the nature of the offense. So like 99% of cases. So not common, assured. But I have been informed that the offense of enticement of a child has been effectively used to prosecute grooming-related behaviors. I just do not want to ensure, I want to ensure that there's no duplication or conflict in our criminal code on these behaviors. And I know that that's come up before. I want to second, and I've spoken with the sponsor and on the House side about this, I want to flag the exemptions piece that's on page 2 that was referenced by Mr. Thompson. Those parties that are outlined, educators, healthcare providers, mentors, and family members, pretty much make up the majority of those that commit sexual abuse. So, and the justification that it's acting in their professional scope is typically what is used. If you think about the Larry Nassar case on USA Gymnastics, that, I was acting in medical necessity was used to justify some horrific child sexual abuse. So I don't want to, it's difficult to legislate grooming because it does mimic normal adult-child interactions. And, we do want children to have a good rapport with their teachers and doctors. So it's kind of hard to thread that needle. So we recognize that. So my recommendation is to work with the Prosecutors Association and folks to ensure that we're not duplicating and that we're avoiding unintended consequences to really address this horrific behavior. So that's just my thought on that. And I also want to separate grooming from sextortion. The sextortion, Evan's family who spoke about that is a practice that is horrific and growing significantly. The National Center of Missing and Exploited Children cited that sextortion cases have grown by 200%. I actually heard them speak about it over the summer. And we've got to make sure our criminal code is keeping up with what is happening to our children. They're also introducing and considering a similar proposal federally. So this is something that's being recognized nationwide. So I think this is a great time for us to look at it here in Missouri.
Thank you for your time again. Any questions? Senator Gregory.
Thank you. I understand you're in support, obviously, so am I, but you started to lose me when you talked about this type of thing being consistent with either normal behavior of a doctor.
Yeah.
I'm looking at this definition. It talks about continuously and closely collectively demonstrating a course of action directed at a minor for the purpose of conditioning, manipulating for minor sexual conduct, sexual performance, these are intentional acts for sex. Talk to me about how that's something that concerns you with a medical doctor's touching.
I think I'm referring to the piece saying that I mean, this is what I had a prosecutor point out to me in conversation, that the language on page 2, like outlining the different parties that this legislation would not apply to, could be used, like in certain cases, kind of as a shield by saying you misunderstood my behavior as a medical provider when I was reviewing the private parts of this child. I mean, this opens up a path of doubt. So that was what was flagged to me as something that should be taken a look at very carefully. The medical provider was something I used as an example, but educators, another one that, I don't know what it's, like I said, it's very hard to legislate multiple points of interaction before it becomes alarming. If an educator is seeking to help a family who's very vulnerable, they recognize that a child is in need of assistance, is what we would consider outside of the grooming, like in another light, additional attention to a family that was hurting. You could look at that behavior and like nothing had happened, like nothing had happened and say that's grooming. You're on the path to grooming. I'm not a defense attorney here, so I don't want to use that, but you could make that argument and nothing had happened yet, and there had been no indication that sexual intent, but you're legislating what you suspect to be happening before it actually happened. So I just think it's a very difficult needle to thread.
I see what you're trying to say. Thank you.
Yeah. But we're certainly in support. I don't want to say that we're not. I just want to be careful and kind of work with, like I said, the prosecutors that would be using this law to ensure it's doing what we want it to do, that it'll be utilized.
Any further discussion? Seeing none. Thanks for your time, and we're going to go to next in support of 893. And after this one, we're going to go to a 1 minute. So you'll still have 3 minutes for your testimony, then we'll move to 1 minute.
Hello, thank you for speaking to me today. My name is Madison Royer with Missourians for Child Protection, a grassroots effort to protect children from sexual abuse. According to the CDC, 1 in 4 girls and 1 in 20 boys will be sexually abused before they turn 18. I've heard child sexual abuse described as soul murder, and I think that really speaks to the depth and gravity of what child sexual abuse is. And grooming has been found by significant research from the John Jay College of Criminal Justice to be present in 99% of sexual abuse cases. Grooming is a tool that predators use to ensure compliance and prevent disclosure from their victims. Grooming is sexual in nature, deviantly so. And it is a specific pattern of behavior that has been incredibly well researched by one of the top researchers in the world, Elizabeth Jeglick, PhD. Her leading research found that grooming behaviors are consistent across sexual abuse with red flag behaviors, and they were able to identify those red flag behaviors and even break grooming down into stages. Our goal with this legislation is not to criminalize the friendly pat on the back or the loving doctor, but to criminalize a malicious and specific, deviantly sexual pattern of behavior. The DOJ, looking at research on sexual grooming, on sexual abuse, concluded that sexual grooming is perhaps the most damaging component of child sexual abuse. And I myself have spoke to victims of child sexual abuse who said it was more difficult to overcome the grooming than it was being raped. And I've seen this in my sisters as well. Research shows that sexual grooming causes PTSD, drug abuse, suicide, depression, nightmares, severe distrust. My sisters were sexually groomed by someone we all knew and trusted. His behavior was sexual in nature, and it was malicious, and it pushed them to the point of seeing suicide as their only option. No normal adult behavior with a child pushes them to the point of seeing suicide as the only way to escape that relationship. He talked about them about incredibly explicit sexual things. He talked about their bodies and gave them inappropriate nicknames like sugar pants and cute butt. He forced them to memorize how to get to his house on foot, the passcode to his gate, the passcode to his garage. He did all this legally. The DSS knows his story. They have listened to my sister's testimony. So has law enforcement. They said because there was no physical sexual abuse, because he didn't rape them, he didn't break the law. They did say he was inappropriate and his behaviors could constitute grooming, but he didn't break the law. I spoke with a woman yesterday whose daughter was groomed by her dad. He took pictures of her, took videos of her, and she was a tiny little girl. While he did all this, he undressed her. And because there was no penetration, this is what she was told, because there was no penetration, he did not break the law, but he did groom his daughter. Our current enticement laws are insufficient. There is a major gap in the law where children are being exploited and significantly harmed by this psychological abuse. Grooming is abuse. I propose that we take the tool of grooming out of predators' hands and hold them accountable for their actions and protect our children. Thank you.
Thank you. Any questions for the witness? Seeing none, thank you again for your time. We're going to move to 1 minute in support of Senate Bill 893.
Good morning. My name is David Barnes. I'm here to represent the Missouri State Council of the ENA, that's the Emergency Nurses Association. We're an international organization of over 50,000 members. I'm here mainly about Sophie's Law. I need to know more about Evans Law, but we'll work on that. And on anything dealing with human trafficking. On that. In 2016, over 40 million people were humanly trafficked around the world. 1 in 4 of those were children. So it's better than 10 million children around the world that were humanly trafficked. A lot of that into the sex trade, unfortunately. We see the worst end of that. In our business as emergency nurses, we usually deal with the aftermath of some of this tragedy that you've heard today. We'd like to help stop that before it gets to our door if we can. We working on various pieces. We recognize that recently, research, 12 to 17-year-old girls have increased, I think, over 60% in suicide rates in the last 4 or 5 years. We don't need the extra work, but we're there to help these people survive and heal. And we're in support of this legislation. And I'll stop there. I have more I could say, but we'll stop at this.
Thank you, sir, for your testimony. Any questions? Seeing none. Moving to the next witness in support, Senate Bill 893.
Hello, I'm Evelyn Dixon, and I'm just going to share a little bit about my story when I was groomed by my martial arts instructor. When he first came, he seemed friendly, like everybody loved him, but he started noticing me. He started texting me, saying he wanted to run a school with me. And it got to the point, he was texting me 24/7, told him to call him every day, and in person, he would send my sister into the basement so he could have private Mikey time with me. It had turned terrible. My life was miserable, and he convinced me it was all my choice. And I tried pushing back, but nothing would change. He would tell me that he loved me, that he wanted to run away with Florida to me. He would talk to me about my body in disgusting ways. He would tell me talk about my body being pregnant with his child. And I went into shock and I could not I went into shock with everything that he did, and he would hold me against his chest and swaying and breathing in my hair, and I didn't move. And he would offer to lay up mats so we could lay together, and I couldn't reply. He would say terrible things to me, and there was just nothing I could do. And so I decided to make this stop. I would kill myself. And 4 days before my suicide date, my family found out what was going, and I thought, finally, I'm free. I can learn to heal, and he's going to go get taken away from kids. But no, I was wrong. There was nothing they could do to stop this monster. He's still out there, free to abuse more girls, and there's no closure and peace for the victims. We just have to live that what he did was okay and legal. Just go. Thank you for your time.
Thank you for having the courage to come here today, and we're going to work together on behalf of this committee, work together to try and stop monsters like that. Thank you for sharing your story. Any questions? Seeing none. Thank you again.
Thank you.
Next witness in support of Senate Bill 893. And just show of hands, how many more are here to testify for 893? All right, thank you. Please proceed.
Hello, my name is Pearl Weldon, and I'm here today on behalf of my daughter Presley, who was sexually groomed at the hands of her high school teacher. He would show her photos of his wife undressed on his phone. He would talk about his sexual encounters in college and with his wife. He would talk about her body every day, how she was dressed. Every day she walked into class, it was, "Hello, gorgeous. How are you today? You look amazingly beautiful today. You're dressed like a mom, and a mom is my type." He would seek her out online, stalk her Facebook, Instagram. She would delete all of those to try to get away from him from doing that. He would touch her every moment that he got a chance to, in front of the cameras and out of the reach of cameras. So a lot of it was not caught on video surveillance footage from the school, but there was a lot that was. The school actually found out about it. It was reported, and they waited 2 days to say something. So she was still groomed for 2 straight days after they found out, before they said something, before they got her away from him. And we asked why. They blamed her. It was her fault. She wasn't supposed to be in his class, but she was. She went to class like she's supposed to. So even the prosecutor said there's absolutely nothing we can do. He's allowed to put his hands on your child. He's allowed to say those things to her. He's allowed to show her pictures that she could graphically, intimately describe verbatim of what they were, but because he deleted them, there's absolutely nothing they could do. They couldn't, there's even the video surveillance footage of what he was doing to her, the things that he would say to her wasn't enough for them to determine it as breaking the law. But they even described it as grooming themselves. They use that term. So they know exactly what it is, but technically he did not break the law. They refused to fire him. They allowed him to resign so he could go into another school, and he will do this again to another child. He shouldn't be allowed to resign. He should be immediately terminated, and they would not. Thank you.
Thank you for sharing your story. Any questions for the witness? Seeing none. Next witness in support of Senate Bill 893. And just for everybody, make sure if you haven't filled out a witness form and dropped it off, grab one, fill it out, and then drop it off before you leave. Please proceed.
Good morning, Chair and members of the Senate Committee. I'll get right to the point. My name is Valoris Juneman, and I'm the founder of the Pathways Project Coalition of the Ozarks. We advocate for vulnerable children and survivors of sex trafficking in Stone and Taney County. Thank you for the opportunity to testify today in strong support of Senate Bill 893 and for all these brave families that are here sharing their stories. Every parent, educator, and community member wants children to grow up safe, healthy, and free from manipulation and abuse. Yet under current Missouri law, the act of grooming a minor is not clearly defined in statute. That gap often prevents law enforcement and prosecutors from intervening until after sexual abuse or exploitation has already occurred. Grooming is not a single message or an isolated interaction. It is a deliberate pattern of conduct carried out with sexual intent designed to build trust, create secrecy, and prepare a child for exploitation, frequently through digital communication. As the founder of a coalition focused on prevention and survivor support, I've seen firsthand how predators use social media, messaging apps, and online platforms to target and isolate vulnerable young people. Without clear statutory tools, many of these warning signs go unaddressed until it's too late. Senate Bill 893 changes that by establishing a proactive prevention-focused framework. For the safety of Missouri's children, especially in an era of constant online contact and digital risk, I respectfully urge a favorable report on Senate Bill 893. Thank you for your time.
Thank you for your time. Any questions? Seeing none. Move to the next witness in support of Senate Bill 893.
Hello, committee. My name is Katie Velasquez. I'm with Family Advocacy Solutions, and I chair the Vulnerable Youth Advisory Board in Southwest Missouri under Senate District 32. Thank you, Ms. Carter. I just wanted to circle back to the enticement laws, and there are people here that are probably more qualified than I am to talk about this, but after some research on the enticement laws, that continues to come up. Why are we not prosecuting under that? I believe enticement was put in place like in the 1970s when we thought that people who molested children were in these white vans and they physically were trying to lure children, and I think that's some of the wording in the statute. So that's what makes this very important, that we know that it's unfortunately not people that are just in white vans. It is people that these kids know. So the language is outdated. That physically trying to lure, that part is outdated. And then updating the statute to have that digital component too, because we know that grooming is happening via text message, via social media. Ohio has passed something similar. I believe that is House Bill 322. They have seen more prosecution under some grooming statutes, so they have seen really positive results. So this is being done in other states. We would actually put Missouri a little ahead of the curve if we can get this done pretty quickly. Obviously, all this legislation is very important. These are great families that we're doing all the right things, right? These are families that are showing up for their kids, but yet these kids were still vulnerable to these predators. So we really need our laws to catch up.
Right on time. Thank you very much for your testimony. Any questions? Seeing none. Any further witnesses in support of Senate Bill 893?
Good morning. My name is Kristen Strimel, and I'm also on Senator Carter's Committee for Vulnerable Children. I hadn't planned on testifying today, but now I feel compelled to. My daughter was groomed, and only when she was 6 months old, until she was 2. It was a horrible thing to be a mother and not really understand what was going on until I did. And the only repercussion I had was to go to my attorney, and we filed for divorce and started proceedings. The thing was, the Children's Advocacy Center, the Children's Center, with what I had as a very young child, they didn't believe us. And it took months and months and months of trying to prosecute him. There were no laws, and it doesn't protect, currently we have nothing that protects a toddler. You know, can they speak for themselves? But I just wanted to say that fortunately I was able to get away just by divorce and by running him down to the point of he had to back off and just say, I terminate my rights. But So I don't know how we protect the most young, but just know that this can happen to infants. And this guy was a preacher, and he wanted to have all sorts of businesses where he was involved with children. He wanted to teach gymnastics. Oh, I can do photography. I can do all these things. My daughter was not protected except for by me only. So we need more laws like this that will help point us towards this is definitely happening. And I think that this bill will help us get there and protect even the tiniest of our children.
Thank you for sharing your story.
Yeah, thank you.
Any
for your time.
questions? Seeing none. Any further witnesses?
Good morning, I'm Russ Tope, the Stop Trafficking Project. So the reality is just perverts, predators, and pimps are preying on kids. And they're using pornography as a grooming process through predatory technology. The Stop Trafficking Project, we have educated and empowered over 141,000 students in our public schools about this exact issue. And last year, kids in middle school and high school were anonymously and voluntarily surveyed, and 44% of the students indicated they had met a complete stranger in person they first met online. At the end of our presentation, 85% of those students said it's no longer a good option. 55% of those students indicated severe addictions to pornography, including sexting and extortion issues that we're talking about today. 97% of the students at the end of our presentation said that's not a good thing. Here's the problem. We're putting the onus of our kids to keep themselves safer from groomers. It's not a responsibility that they are capable of encountering with their brain development. It's time for Missouri to become the show me state to where we put legislation in place that actually isn't even going after the technology. There's a lot of legislation on that too. Let's go after the groomers and their activities.
Thank you for your time, your testimony. Any questions? Senator Gregory.
Quick question. Are you an attorney?
No.
Okay. I'm reading the enticement statute, and so I'll probably just make more of a comment than a question. It's frustrating to hear these prosecutors aren't prosecuting. I'm very much in support of cleaning up and making it easier, right? No reason not to, because these crimes are heinous. But I'm just going to tell you what the current statute says. Any person 21 years of age or older, which is every situation we've heard today, that they commit the offense of enticement of a child if that person persuades, solicits, coaxes, entices, or lures. And it can be by words, it can be by actions, it can be through communication via the internet or any other electronic communication for the purpose of engaging in sexual conduct. So I'm just going to go on record and say that's absolute BS that these prosecutors aren't prosecuting. But yes, we will do more to make it even easier because they're not willing to do it. Thank you.
And Senator, I appreciate that because we literally have thousands of disclosures, and kids come to us with tears in their eyes, and it is the most helpless feeling after the fact to tell a student, the system is so broken, there's nothing I can do to help you right now. Therefore, we have to put things in place to end it before it starts. As you've heard, the grooming process can sometimes be more difficult to get over than the actual rape, than the actual sexual exploitation. And that's where I appreciate the heart of this community to do everything you can to keep our kids safer.
Thank you. Any further discussion? Seeing none. Next witness in support of Senate Bill 893. Seeing none. Any in opposition? Seeing none. Any informational purposes? Seeing none. That will conclude the hearing on Senate Bill 893. I'm going to hand the gavel over to the vice chair as I have a presentation upstairs. We're going to move to Senate Bill 982 from Senator Coleman, and then the last bill will be Senate Bill 1067.
Thank you, Mr. Chairman.
Senator Coleman, now that I'm chairman, I'm going to speed things up to make sure that we get to Senator Henderson's as well. So
Fair enough for me.
please go as fast as you can. I'm going to be limiting the witnesses as well. Thank
Absolutely. I think that this shouldn't take very long. Senate Bill 982 is clarifying 2018 language that overwhelmingly was passed, but as usual, the Missouri Supreme Court has determined was poorly drafted. And so we have worked diligently with the Missouri Highway Patrol to try to find ways to make sure that that law is going to be enacted. Right now, we have a problem where low-level offenders like public urination are being classified in the same way as contact offenses with children. And so we're needing to make sure that our statutes, in order to be punitive and that victims know what justice they're going to be receiving, is done across the line. There's also some concern right now, some cleanup language in a number of ways about what to do with offenders who were out-of-state offenders but who have significant contacts in the state, what to do about people who the courts no longer have documentation that is needed to be able to file certain petitions. So there's cleanup language in here as well. Happy to answer any questions of this committee, but in the chairman's interest of being brief, that's
Thank
the
you
fast
so
overview.
much. Questions for the senator? Seeing none, thank you, Senator. First witness to testify in favor of Senate Bill 982. I am limiting testimony to 2 minutes or less. Please proceed when you are ready.
30 seconds. Jessica Seitz, Missouri Network Against Child Abuse. Going on the record in support of this legislation. Senator Coleman has done a significant amount of work on this and worked with those who are more in the know than myself. I thank her for her work and hope this goes over the finish line this year.
Thank you. Next witness to testify in favor of Senate Bill 982.
Good morning. My name is Sarah Vatterott. I'm an attorney in private practice in St. Louis, and I'm here today to kind of talk about some of the technical aspects of Senate Bill 982. I want to stress that this is a corrective bill, as the senator states. What this is doing is ensuring that the law, specifically regarding the removal procedures, are consistent with what the General Assembly in Missouri passed in Senate Bill 655 back in 2018. We're not changing who has to register. We're not eliminating registration for serious offenders. We're not weakening public safety. What we are doing is fixing a procedural contradiction that currently prevents the Missouri courts from carrying out what the legislation, what was passed and what it went into law in 2018. So I'll keep it brief, just a little bit of background. The Missouri Sex Offender Registry was adopted in January of 1995. And from 95 until 2018, if you were on this, essentially, no matter what your crime, it was a lifetime registration with a very few limited exceptions. In 2018, Missouri came in and amended this. And what it did at that time is it adopted a tiering system. Tiering system identical to that under federal law. And so with Tier 1 offenders, who are the lowest level offenders, they are required to register for 15 years. Tier 2 are required to register for 25 years. And Tier 3, the most serious offenders, it's lifetime registration. And as part of this bill, what Missouri did is that they adopted 589-401. That was an entirely new section, and the whole purpose of that is to lay out the court procedure. Here is the procedure for how you can petition once you've met your time.
Go ahead. I'll give you
Thank you.
a little bit of time to wrap up.
Once you've met your time to be removed from the registry. The issue is that despite the legislature's intent, despite the fact they adopted this entire section, when it has come to the Missouri courts, when they have looked at it, they have said, no, sorry, there's some language in there that says any person that has been required to register. They've said, federal law, you have an independent registration requirement, so I'm sorry. Even though you have completed everything you need to do under Missouri law, even though you have passed the time period for your registration requirement under federal law, you've maintained a clean record, you've had no other violations, and the court even comes in and finds, yes, you are not a potential or current safety risk. The Missouri courts' hands have been tied. They say, sorry, we can't, because the way that we read this, it states that there's an independent requirement under federal law. And that is not what it has. That is not what was intended by that. If we're reading at this, and there's been this particular, these particular sections, there's been, in the last several years, 4 or 5 cases at the Missouri Supreme Court. Clearly, there's an issue with this. And so what we have is a tiering system that the state adopted people that would be eligible. We have an entire removal procedure, yet we are still same thing as lifetime registration. And so what we're trying to do is not trying to reduce public safety, it's simply statutory conflict. So there's language, and I can talk to the specific sections in there. And again, with working with the Highway Patrol, who's the one who is dealing with all of these cases. You can imagine if there's 5 or 6 at Missouri Supreme Court, you can imagine how many cases are taking up the court's time, the Attorney General's time at the Court of Appeals level and district level, of course, circuit court level. So
we
yeah.
will have to wrap up. We'll have to
Okay,
wrap up.
sorry.
Yep, that's
So I
okay.
just simply would ask, and I can answer any questions afterwards if I have time, but we are just simply asking the court to honor, asking the legislature to honor what was done in 2018, fix this error, make it accurate, intentional, so there is not a conflict, so the Missouri courts can follow what was intended in 2018. Thank you.
Very good, very good. Clearly, you're very knowledgeable. Questions for the witness? Seeing none, now you don't happen to be related to any lobbyists in the building, right?
God.
Oh,
guess
well,
I'll
I'm going to have
claim
to
'em.
cut your testimony off right now.
Yeah.
David Jackson. Thank you so
Yeah,
much. You
thank
did a
you.
great job. Next witness to testify in favor of Senate Bill 982.
I would like to clarify, I don't think that David Jackson has a client on this issue.
Well,
this
then we're
is
back in the
a mere
game. All right,
coincidence.
we're back in the game. Any witnesses to testify in opposition of 982? Seeing none, anyone to testify for informational purposes only? Seeing none, this concludes the hearing. Senator, any closing remarks?
No, I just wanted to say we have worked closely with the Missouri Highway Patrol. If the Prosecutors Association has any comments as well, any other law enforcement officers, we're trying to make sure that Sarah was kinder to the Supreme Court than I was. I don't think we need to pass a new law. I think we need to get the Supreme Court to start following what we pass. But if they won't, then we'll keep trying.
Thank you, Senator. This concludes the hearing on Senate Bill 982. And now, Now we will hear Senate Bill 1067, sponsored by Senator Henderson. Senator, we are about to run out of time, but you may proceed when you are ready.
Thank you, Mr. Chairman and committee members, for allowing me to present Senate Bill 1067, sometimes known as the SLAP Act, dealing with strategic lawsuits against public participation. I'll give you a quick overview of it. It establishes a Uniform Public Expression Protection Act to protect Missourians from meritless lawsuits that aim to silence their First Amendment rights. Based on a model act from the Uniform Law Commission, a nonprofit that drafts nonpartisan state legislation, SLAP, strategic lawsuit against public participation lawsuits, are used to punish speakers with costly litigation to suppress their free speech. Even if a defendant wins, the financial burden discourages them and others from exercising free speech. It covers all forms of free speech related to matters of public concern, not just those tied to public hearings or governmental proceedings. This includes posts on social media. It grants a clear right to appeal an anti-SLAP motion immediately, avoiding lengthy litigation, and requires a plaintiff to prove up front that they have a valid case with a chance of winning. I think you've heard this for several years probably. And with that, I know you're running out of time. I will take any questions.
Thank you, Senator. Questions for the Senator? Seeing none. First witness to testify in favor of Senate Bill 1067.
Good morning, Mr. Chair, members of the committee. For the record, James Harris. I'm a registered lobbyist for the Institute for Free Speech. We've been supportive of this bill for, I think, 3 or 4 years. It's passed out of the chamber, actually both chambers, multiple times, bipartisan votes. It's been like the little train that could, but it's ended up dying in a judicial omnibus bill at the end of session. It doesn't change the standards for evidence, just merely allows the individual, if they feel they're not a party, to petition the judge. And with that, I'm happy to answer any questions.
Thank you. Real quick, this doesn't completely make immune any statement if it's made in a public body, right? Like,
correct.
Okay, there's still protections for our folks. I mean, for example, you can't come in here and start slandering a company. And so what are those, do you know those basic protections?
Well, all this does is, if it's normally in slander suits, where it's after discovery, where I'm petitioning the court or the judge to release me.
Dismiss it,
This is just
yep.
moving up that process on the petitioning the judge. That's the evidence, nothing else changes.
Got it.
Sorry.
Thank you very much. Any further questions for the witness? Seeing none, thank you. Next witness to testify in favor of Senate Bill 1067.
Good morning. I'm Chad Stebbins, Executive Director of the Missouri Press Association, also representing the Missouri Broadcasters Association this morning. We support this bill. It would protect journalists and others against frivolous lawsuits that would interfere with their First Amendment rights. News organizations and journalists across the country are frequent targets of these meritless lawsuits that silence reporting through expensive, protracted litigation. So I'd be happy to entertain any questions you might have.
You mean to tell me with this legislation I can't sue the press?
Exactly. No, you still could, but it would be much more difficult.
Questions for the witness? Seeing none, thank you so much. Next witness to testify in favor of Senate Bill 1067. Seeing none, any witnesses testify in opposition of Senate Bill 1067? Seeing none, anyone here to testify for informational purposes only? Seeing none, this concludes the hearing on Senate Bill 1067. How do I adjourn?
Ask for it. Motion.
Motion to
Second.
adjourn. All right, we are adjourned.